Good morning.
Good morning, Your Honor. Mark Watt on behalf of the defendant, Mr. Robert Allen. Your Honor, there is an oral motion that I'd like to make, actually two.
Okay, just a moment. Mr. Allen, your name for the record, please.
Robert James Allen.
Okay, so today's the date scheduled for sentencing in this matter. This was adjourned from April 28th. And, counsel?
Yes, just so the court's aware, Your Honor, Mr. Allen did renew his medical marijuana card. He brought it with him. But the motion is, well, the first motion would be Mr. Allen would respectfully request the opportunity to withdraw his plea based on what I believe to be the perception of my ineffectiveness in representing him during the plea negotiations and his acceptance of the plea. He's, without breaking attorney-client privilege, he doesn't believe that I properly advised him. So the first motion would be to allow Mr. Allen the opportunity to withdraw his plea in the interest of justice if he so chooses. All the witnesses are police witnesses and all the evidence is captured on body cam and video. So I don't think the prosecution will be prejudiced. The second motion.
Well, hold on. Before we move to the second motion, I'm not going to even consider an oral motion to withdraw a plea. That all has to be done right. So that the prosecutor has an opportunity to respond.
I understand.
Because this plea was taken on March 12th, so now we're over 2 months ago, and I need to be able to review the motion to determine whether or not that is something this court would grant. And counsel, your next motion.
The second motion, Your Honor, would be, since there has been a breakdown in the attorney-client relationship, I would respectfully move to withdraw from the case so Mr. Allen could either secure new counsel or request court-appointed counsel so that they could properly file the motion. I don't know if they want to file against their hearing or anything, or if the prosecution would be in opposition to it.
Okay, and so counsel, when did this all come about?
Well,
did it just come about this morning?
We have been discussing it for a few weeks, and this morning it just came to a head that I can't effectively represent Mr. Allen anymore in line with what he believes to be his best interests as opposed to my conflict with what's happening here.
Okay.
I was retained, and I'm candid with the tribunal, I was retained by a third party who did give me $2,000 to represent Mr. Allen. I proposed that I refund half of that to Mr. Allen at a minimum so that he could.
You refund that to Mr. Allen instead of back to the third party?
To the third party, but basically if they wanted to help him again, I can't in good conscience or refund all of the retainer. I've been down here several times and put quite a bit into this matter so far. So I will be refunding $1,000 to that individual.
Okay, so my question is, counsel, if this was something that was a possibility, why there wasn't a written motion filed before this morning?
I literally believed everything was fine when I was informed of the medical marijuana card, and that was just the cold feet issues that some of my clients have, and until they give me like clear, unequivocal, I couldn't interpret. I didn't know, you didn't tell me I want to withdraw my plea in any other light than, okay, you're telling me you believe I was ineffective at this point, and what my thoughts were aren't in line with what his beliefs were during these last few weeks. So I do apologize. You're correct that if I knew, I should have filed a written motion, but we discussed it. I said I could withdraw as your attorney, you could find someone else and things like that without getting into the nitty-gritty of it, but it was my belief that the representation was still intact and we were on the same page. And I apologize for interrupting the proceedings earlier, that's when it basically clicked that this is something that I need to bring forth and make these requests.
Buckle up, guys. Today we are going to dive straight into a courtroom drama that's got everything. Chaos, arguments, and a defendant who thinks he knows the law better than the judge. Right from the start, we get a fiery setup, cases about sovereign citizens and a CPS meltdown, and then the spotlight shifts to Robert Allen. The judge calls his name, and you can feel the weight of what's about to unfold. This is just the calm before the storm.
You have been to court a number of times with Mr. Iwata, correct?
Yes,
And you've had opportunity to speak to Mr. Iwata on a number of occasions, correct?
yes,
And you also have had the opportunity to review discovery with Mr. Iwata, is that correct?
yes,
Okay, and Mr. Iwata has been your attorney since January, and there's been a number of court dates that have been scheduled. In fact, you all were here April 28th, and we did not hold the sentencing because your client indicated that the CCH was inaccurate based upon what you had represented and requested time to adjourn that to revisit that issue.
And it has been corrected by probation, Your Honor.
Correct. Would that be correct, Mr. Allen?
yes,
All that is correct, right?
yes,
Okay. And so now here we are at the date of sentencing, and you want to have a different attorney, and you want to withdraw your plea.
I don't necessarily want a different attorney, but I want to withdraw my plea because I don't feel, first of all, probation ain't even part of the punishment for what I pled guilty to. I took the plea agreement thinking you were going to sentence me accordingly to what the first offense misdemeanor is for.
Okay, and so
You're
what is
trying
that,
to put me
sir?
on
So-
probation and that's not even part of the punishment.
Pause just a moment. What is it that you believe is the punishment for a first offense misdemeanor?
MCL 750, whatever else it says on there, the punishment is only 93 days in jail, $300 maximum fine, community service, a 30 to 90 day license suspension, and up to 4 points on your license. I already got the 4 points, I already got the 90 day maximum suspension. I know you're gonna charge me the $300 maximum fine. I feel like that's more than enough punishment for a first time misdemeanor offense. I've never been arrested for anything alcohol related in my life. I'm 48 years old. Never been in trouble in Wyandotte. You're trying to, the clean slate law is supposed to erase my whole record. You're not even supposed to be bringing up my past record on me. Not the probation department lady already lied on me, put stuff on my record I wasn't even convicted of, putting 12 to 18 months probation. That's not justifiable for punishment for what I did. What I did is, it doesn't even include probation for the punishment.
Your Honor, Mr. Allen's statements to me was I did not disclose to him that probation was a possible sentence. And those
Probation ain't part of the
Stop
punishment
interrupting the
though.
record, Mr. Allen.
So I want to pull my plea because
Stop interrupting the record. Your attorney is speaking right now. Just one moment.
And I do not recall telling him that yes, probation could be part of the court's sentence or that no, probation wouldn't be part of the sentence. I just assumed that Mr. Allen knew that probation could be part of the court's sentence.
Okay.
it's
So
not part of the law.
I understand that, sir. Nevertheless, Your Honor, there has been a breakdown in this relationship and I can no longer in good faith continue this representation, Mr. Allen, not only for the defendant, protecting the defendant's interests, but also now my own interests because I'm in a position where I could be looking at a possible grievance if I continue representation at this juncture.
Okay. Mr. Allen,
Yes, ma'am.
so you're telling this court that the matters that you have on your criminal record, that those have all been dismissed?
No, I said I qualified for the clean slate law and it was my understanding that my past record would not be brought up again.
Here's where things heat up. Allen's lawyer steps in with not one, but two surprise oral motions, asking first to withdraw Allen's plea, then to withdraw himself from the entire case. The judge isn't having it, shutting down the plea withdrawal and pressing for real filings. What was supposed to be a routine sentencing instantly turns into high-stakes legal chess. The cracks in Allen's defense team are already starting to show, and the tension is building fast.
Here I am. And
Hold on,
everything on my record is...
We're gonna take one thing at a time. You understood that you were eligible for the clean slate law, so what does that mean to you?
The lady the representative told me that we went over my record. The CCW on my record, the false report of a misdemeanor, the attempt to receive and concealing, all that was supposed to be erased off my record. It was never supposed to be brought up against me ever again. I was told if I got in trouble again, that none of this would be brought up against me. It would be like I'm getting in trouble again for the first time. So, therefore, the probation...
Which convictions are those, sir?
Huh?
Which convictions are those that you're speaking of?
The CCW conviction from 1997, the false report of a misdemeanor from 2004, and attempted receiving and concealing from like 2012 or whatever, or 2010 or whatever that year was. All of them are more than 10 years ago. You ain't even supposed to be bringing this up against me.
First of all, 2010 isn't on here.
Well, whatever the year was for the attempted receiving and concealing.
Okay, that's not on here, sir.
Okay, so well, everything else, so there should be nothing on my record.
That's not true. That's not true.
What? There shouldn't be nothing on my record then.
You have a number of criminal convictions, more than just what you spoke of. And the clean slate law, there are certain convictions that are automatically wiped off per the Michigan State Police, from the Michigan State Police per that law.
Yeah.
Sir, the court is looking at some of these, and if you
You're
are
trying to prosecute me for my past. Say it.
Sir, the court doesn't prosecute. Let's clarify that. The court doesn't prosecute. If you are eligible for any of these convictions, sir, to be removed from your record, then you have to follow the steps that have to occur, right? There's motions to set aside, there's applications to set aside convictions and whatnot. So those are the steps that have to be followed. Some of these are not automatically wiped off.
Can I say something though? I was told since I was a Detroit resident that it does automatically get wiped off. I didn't have to do nothing. The system would automatically update itself.
Okay,
As
well,
a Wayne County resident, that's what I was told.
Detroit resident or
A
Wayne County?
Detroit resident, I'm sorry. As a
Okay.
Detroit resident, if the system was supposed to update itself and erase itself, I didn't have to do nothing.
Okay, well, I have to tell you, that's the first I've heard of that. I haven't heard that anything is resident
Well, you
specific.
probably haven't had to go down there and talk to somebody that had your record expunged either.
Sir,
Man,
I'm still given the laws to review when they're passed and then they're enacted. So I don't recall seeing anything about being resident specific. And then why would it be only a benefit of Detroit residents if it's a state statute? So whatever that is, I don't know. I don't know if there's a misunderstanding somewhere. I don't know.
ignorance ain't an
How-
excuse for not knowing the law.
You're correct,
Ain't that what
sir.
you tell me? That's what you would tell me.
You don't presume what I would tell somebody or you. Do not presume that, sir. Now, as well as whether or not probation is something that is a possible consequence, okay? Probation is something that the court would order in lieu. Sir,
Excuse me.
those gestures are not necessary. The gesture of money, money, money,
That's what you
not
want, right?
necessary. No. Probation is something that courts impose in lieu of jail, sir. Now, under MCL 769.5, have you reviewed that one, sir?
No, I haven't.
Okay, then I would suggest you review it, because that gives the court judicial discretion if it determines that there is a rebuttal, that the presumption has been rebutted to sentence somebody to probation. Now, if you don't agree to probation, that's your right. And the court also has the right then to impose jail, if that's what the court determines it's going to do. The court also has the right to impose fines and costs only. The court has a lot of judicial discretion, sir, in imposing sentencing. So,
With all due respect, I apologize, Your Honor. I just feel like the recommendation by the probation department is way too harsh for a first-time misdemeanor.
Now, the judge goes straight to the defense attorney, demanding answers about why this wasn't filed earlier. The lawyer admits a client relationship has collapsed, confesses a breakdown came to a head just that morning, and even offers to refund half the retainer fee. It's awkward, uncomfortable, and telling this isn't just a disagreement. It's a full unraveling. In court, when the attorney-client bond breaks, the whole case teeters on the edge of disaster.
you have the right to have that opinion. You
I
absolutely have the right to that
I just wanted to
opinion.
say that, Your Honor. I apologize. I'm not trying to be disrespectful. I just don't agree with the punishment for the crime. That's all. If you put me on probation, I feel like you're setting me up for failure. That's
And
all.
why is that?
Because first of all, I'm on SSI. My $900 a month is gone before I get it. I don't have no thousands of dollars to give you. My license has been suspended
Let's
for
clarify,
90
not
days.
giving it to me, sir. Let's clarify, you're not giving me money.
But I'm saying I don't have any money to give anybody, is what I'm saying. The 90 days, my license has been suspended for the maximum 90 days. I haven't seen my granddaughter, my goddaughter, or my kids in over 30 days. I'm stressed out, I'm sad, I'm depressed, I'm sorry.
Okay, sir, I can understand and appreciate all of
I feel
that.
like
But let me just clarify.
this is my first time.
Let me clarify,
I
sir.
feel like this is more punishment.
This court does not suspend your license. The Secretary of State did that.
I understand it, but it's still a punishment, a part of the law of the punishment. And I've gone through that punishment. And now I'm hurting because I can't see my own kids now.
And why can't you see them?
Because my license are suspended.
They can't come to see you?
My son don't have a car. You know what I'm saying? My daughter, she goes to nursing school. She's a full-time mother
Okay, so where does your daughter live?
in Woodhaven.
Okay, and you reside?
I live in Detroit, and it costs a lot of money to take an Uber back and forth that I don't have the money for.
Okay, what a bicycle? What about a bicycle? What about somebody
I'm
else?
disabled. I'm gonna ride a bike from Detroit to Woodhaven.
Sir,
You're asking me, man, this is ridiculous, man.
I'm just asking options.
Can I just get a fine and go about my way, man?
And sir,
You're trying to punish me too much for a first-time misdemeanor offense. I've never been arrested for anything alcohol-related. This is a 90-day misdemeanor. You're talking 12 to 18 months probation. That doesn't fit the punishment of the crime, man. That's too harsh. Even with the criminal record that I have, 12 to 18 months probation is too harsh. I haven't committed any crime. I haven't been convicted of anything in more than 15 years. This is a first-time misdemeanor offense. It should be a fine and my license suspended and have a nice day, sir. If I come back here again 2 or 3 times to keep drinking and driving, yeah, then I can see getting 90 days and all these probation and all this. But this is a first-time misdemeanor offense. I feel like you're being way too harsh on me.
sir, I haven't assessed anything at this point.
But I already know what you're gonna do. I sat in your courtroom and watched you sentence 10 people. And ain't nobody walked out of here with under $2,000 in fines, all kind of probation and everything, bro, for misdemeanors.
Okay.
This guy just got all this for all these probations and 2 years probation and he did assault and all this and you're trying to give me 12 to 18 months probation for a simple misdemeanor?
Sir, first of all,
How could they even recommend that, bro?
your conviction is eligible for early discharge. So if you wanted to start comparing the
It's
cases,
not eligible.
stop interrupting me. Stop interrupting me. If you want to compare cases, then you need to have all the facts. You don't know all the facts on every case. This court takes every case, every individual that comes before it, and reviews the report, the recommendation, criminal history, what other special circumstances there are before this court fashions a sentence. Now, it may seem from your perspective that they're very similar because some circumstances, right, some offenses benefit from similar rehabilitative conditions.
It's a simple misdemeanor charge, man.
That's your opinion, sir. That's fine.
Blown out of proportion. That's all I'm saying.
Well, sir,
If I
you
come
also
back 2 or 3
have,
times.
you also have the option of after you consume the beers to have somebody else drive you home, then you wouldn't be here.
You're right. And I really want to go to trial because making me blow 13 breathalyzers and charging me with something that with only one, you know, I was falsely arrested anyways. I was falsely arrested. The officer told me, I don't like how you're talking to me. If you don't quiet down, I'll take you to jail for disorderly conduct. That's not disorderly conduct.
Okay, stop, you're done. I'm gonna.
I want to withdraw my plea and go to trial.
Sir, stop talking, please. Stop talking. The court's going to grant Mr. Arlata's motion to withdraw. Based on the breakdown of the attorney-client relationship as far as the direction of resolution, it appears that there's a clear difference of opinion. Mr. Allen, are you intending to retain
Oh, yes,
other counsel?
I'm gonna hire another lawyer. Somebody that's gonna fight for me. I took this plea to be cool, you know? I wanted to go to trial the whole time.
Sir, you don't need to keep talking. Stop
Okay,
talking.
I'm just
Stop
saying.
talking. As of now, this is still scheduled for sentencing until this court receives a written motion regarding a plea withdrawn. So, sir, when whoever it is that you're going to be speaking to and retaining, when your attorney sees that on the docket it's scheduled for sentencing, that's because that is what's currently on the docket for procedurally. There's not been a written motion to withdraw the plea. This court's not going to entertain an oral motion because the prosecutor has an opportunity, has to have an opportunity to review the motion and file a response. So we'll adjourn the sentencing.
So I'm not gonna be able to pull my plea and go to trial? I'm just gonna be able to hire another.
Alan finally takes a spotlight and is adamant probation isn't part of his sentence. He argues the law only allows jail, fines, or license suspension. But the judge pushes back, pointing out his own misunderstanding. Alan insists he was misled, convinced he's being punished beyond the law. This isn't just a dispute over details. It's a fundamental clash between courtroom reality and a defendant's imagined version of justice. The tension climbs with every word.
Listen to what's being said, or are you just wanting to say what you gotta say?
I'm listening to you,
What
I'm
else?
asking for clarification.
What I said, sir, was that it's going to be scheduled for sentencing because that's what's currently procedurally scheduled.
I understand that part.
There has not been a written motion received by this court yet.
Okay.
So once there's a written motion, it will be set for a motion date.
Oh,
But as of now, this court's not just going to set it for a motion date because I have no idea who you're going to retain and what that attorney's strategy is going to be.
Thank you, Your Honor. I just wanted clarification. I'm sorry. I apologize.
You will adjourn sentencing to be June 18th. At 9:30 a.m. That's a Wednesday. And I did that so that in the event your attorney files a motion to withdraw the plea, it will be set on a day that's a wind-down day. So that will be a motion hearing date. Now, sir, I'm sure Mr. Arata is going to tell you that there's procedure for motions. Notice has to be given so that you need to retain an attorney sooner than later. If you're in a test right now, sir, what's in your system?
Just marijuana, Your Honor, like always.
And when did you obtain this medical marijuana card, sir?
I went and got it like probably 10 days ago.
Okay, and so did your treating physician give you any documentation to?
My primary caregiver, she retired, Your Honor, so.
No, sir. I
Yes,
asked
she
you your
did.
primary caregiver.
I mean, not primary caregiver, I mean, my primary care physician, my primary doctor that I used to go see,
Okay.
Wendy McKay, she retired, so I don't have no way of like going in and talking to her anymore or nothing, so.
Okay, when did
I
she
would have to
retire?
get it, a couple years ago.
Okay, so who have you seen in the meantime?
I haven't seen nobody because they sent me, the new doctor that they assigned me was way out on 14 Mile and something, and I didn't need to go to the doctor since then, so I just never been out there.
Well, sir, the court does not accept a marijuana card from a marijuana clinic. The court indicated that the court already indicated what the requirements
I
were.
told you a doctor, you can't go into your doctor and say, hey, doctor, can you write me a letter saying you feel like I need to be on weed? Doctors don't do that. You
That's
can't do
incorrect.
that.
That's incorrect, sir.
I don't know what doctor you talk to, but they don't do that.
Sir, I'm not.
I asked my doctor before
I
for
told
that,
you what the.
and that's why I got the card.
Sir.
They don't do that.
Well, you know what? Then we're gonna have to hold a hearing on your card and whether or not that doctor's going to come in to see how long.
Let's
that
just
doctor's
handle
been
this
treating
first,
you.
okay?
I'm sorry?
Let's get let me hire the new lawyer, let's go get this, because we can argue about that later, man.
Well, in the meantime, sir, you're probably going to be coming back for a bond violation.
Yeah, okay. I didn't violate my bond. What are you
Sir?
talking about?
Sir, you're using marijuana That's in violation of your bond conditions right now.
You told
And
me
once,
I
and
did medical
once you've
marijuana.
been under the jurisdiction of this court, the requirements for medical marijuana are clear.
You know I'm using it for medical reasons. You see my paperwork, Your Honor. Why are you doing this? This is what
Sir,
I'm
if
talking
you have
about.
medical reasons, then you would have a doctor that you are treating with that would determine whether or not the medication is appropriate. I'm not going to argue with this any further. If you're testing and you're testing positive for marijuana, then
This part is all about the so-called clean slate law. Allen argues that his old record should be wiped away, making this case a true first offense. The judge wastes no time correcting him, explaining his understanding is flat out wrong. What Allen thinks is a shield is nothing more than wishful thinking. This isn't just a legal correction. It's a sobering reality check where the law strips away his defense and leaves him standing exposed in the courtroom.
Defendant Jose Elizondo, who's set for pretrial hearing, and I need to go ahead and call that, and then I'm going to get the interpreter for Ms. Mohammadi. Okay, so Mr. Elizondo, you have case G 4791701, charges expired registration. You were in court in April 1st, I believe it was, and indicated that you wish to plead not guilty and represent yourself, but you were not waiving a jury trial. So we set this for pretrial hearing. Court issued a pretrial order that was sent to both parties. I do not show that either side filed any motions or requests for subpoenas or request for jury instruction. Mr. Bishop, did the state file any?
No, Your Honor.
Okay. Mr. Elizondo, did you file any?
Yes, I actually certified mailed it to y'all. I have the receipt right here.
When was it mailed?
It said you should have received it on the 1st of this month. It was mailed on 04/29/2025.
We don't have it.
Well, you should have received it on the 1st. I certified mailed it.
Do you have the green copy back?
I have it right here.
No, the signed that it was delivered.
I mean, I have a tracking number here, but I haven't tracked it. It just says y'all should have received it on the 1st.
Well, we have not received it. We have not received anything. And everything was supposed to be filed with the court no later than 7 days prior to the pretrial hearing. So if you were sending it in on the 29th, you were not getting it here within the 7 days. All right, Mr. Elizondo, Mr. Bishop. So Mr. Elizondo, I just had my court staff run that number through USPS tracking, and it does not show that it's been delivered. It still shows that it is in transit. Are you saying that you are looking at something that says it's delivered? Not something that's estimated. Are you looking at something, sir? You said this shows that it was delivered. What were you looking at?
Was estimated delivery date. Oh.
The judge begins dismantling Allen's arguments piece by piece. Allen insists old convictions are gone, but the court holds a record in hand and proves otherwise. Case after case is brought up, reminding Allen that his past hasn't vanished the way he claims. The exchange is tense, and you can almost feel Allen's confidence slipping. What he thought was a clean slate turns into a wall of criminal history, and the judge is holding every card.
Look up the tracking number on my side too.
Well, no, I have. I mean, you can look it up, but the court has. So that the court is taking note that it does not show that it has been delivered. And so, what motions were you filing, or what were you filing?
I was just trying to post bond, but I mean, I'm still going to proceed to declare not guilty, regardless if you got.
You don't need to. You said post bond. You don't have to post a bond. So was that just a bond you were sending in?
Yeah.
Okay. No, you cannot post a bond yourself. Okay, unless are you a licensed bondsman?
No.
Okay, so you have a promise to appear, and that's all you need to have at this time. You don't have to post any sort of a bond. So you weren't filing any motions. You were not filing a motion for discovery or any requested jury instructions or anything like that.
I was, but I can't remember what I filed, but I have the documents somewhere else. I don't have them on me right now.
Where would they be? Why do you not have them on you? Because if you thought that this is your pretrial hearing, this is where they were going to be heard.
Okay. I still wish to proceed now guilty. I don't need them to
No, sir,
proceed
stop,
anyways.
stop. We're not going to the plea at this time. I'm trying to confirm. I asked you, I stated that we hadn't received any motions, and then you said that you mailed them. We've not received that. Then you said to me it was a bond. So I'm trying to determine. You were just trying to file a bond. Is that correct?
Yeah,
Okay. You did not have any written motions or requests for anything. Is that correct?
that's correct.
Okay. So then, since you don't have to post a bond because you have a promise to appear, we can go ahead and set this for jury trial. So jury trials will be during the day. We'll start at 9 a.m. Parties are to be here at 8:30. The veneer panel will be here at 9. And we'll have the trial. So the first date that we have is August 28th, which is a Thursday at 9 a.m. All right. So, Mr. Elizondo, we're going to set this for trial Thursday, August 28th. At 9, you need to be here at 8:30. This will be in person in the courtroom.
That's fine.
If you are planning to call any witnesses, you need to have them here, present, to be sworn in and able to testify. Understand?
Got it.
Okay. Do you have any questions about this?
No. Well, are you going to send me this information via email?
We're going to send you a reset notice. Yes. Yes.
Make sure that email is correct because today I received the email saying this court hearing was going to be at 6 a.m. and I was present.
Sir,
and it was
I
6 p.m.
apologize if there was a typo. I do know that you also received numerous communications from the court that said 6 p.m. And when I set you for this hearing, I told you it was at 6 p.m. So you were advised that by the judge, and we have copies of emails and documents that were sent.
And make sure that
Sir, Mr. Elizondo, do not speak to the court that way. You may make a request, but do not speak to a judge and tell them to make sure to do something. Do you understand me, sir?
Here the drama hits a boiling point. The judge explained probation is part of judicial discretion, while Alan grows more agitated, calling the punishment too harsh for his misdemeanor. He interrupts, compares his case to others, and accuses the system of setting him up to fail. The courtroom turns into a verbal battleground, with the judge trying to restore order. It's raw, it's heated, and it's Alan openly fighting against the very process that holds his fate.
Petition for reinstatement of parental rights in cause number 71833 L1 involving the Lessner children. Was Lessner children, not Lester anymore. Before we get started, Mr. Hill, you represented Miss Lester originally, correct?
Judge, I did, and then she opted to represent herself, if memory serves me correctly, and you left me on as standby counsel.
Okay, all right. So for purposes of today's hearing, Miss Lester is now treated as a kinship, so she's not entitled to a court-appointed attorney, so you're not bound to stick around if you'd like to go. I felt like I had to notify everybody just so if anybody had any information that the court thought it should hear, that's why you're here, but you're not bound to stay here.
Judge, I'm here. I might as well stick around.
Okay. All right. Okay. You won't be asked to participate unless, you're called as a witness. So,
Okay.
Okay. Thank you for showing up.
Yes, sir.
Okay. I will call the case again. We've talked about Mr. Hill, why he's here. Ms. Surratt is here representing the department. Mr. Nowak is here representing the children. He was appointed for purposes of this hearing as required by the statute. And again, Ms. Lessner is with us. Okay, before we get started, Ms. Surratt, you had a motion to dismiss. did you have any exhibits you wanted to introduce? I think we can take up that motion to dismiss first because I think it's going to be dispositive of today's hearing.
Yes, Your Honor. I sent out exhibits 1 through 4 or 5 to the parties. I sent that out yesterday, and I would move to admit petitioners exhibits 1 through 5. As far as the motion to dismiss, it is a bar to filing the reinstatement of parental rights under 161.302 B3 if the children have been adopted, and these 4 girls have been adopted, and that's in petitioner's exhibit number 1.
Okay. Ms. Lessner, do you have any response to that?
I don't know why I was muted, but I would object to allowing the state to have a dismissal knowing that my parental rights were illegally terminated. It doesn't matter how you cut the cheese on the rights terminated. The state asked the jury to terminate my parental rights simply because my husband at the time was accused of a crime. You cannot, under Texas state law, terminate parental rights on someone else's accusations. They had to find some kind of lawful reason to have me terminated from my parental rights, and they did not. The state has made those claims, and I have taken it up with the Department of Family and Protective Services in the commissioner's office. And they are the ones who told me there were no findings of guilt on my part, and I should have my children.
The final act seals Alan's downfall. He insists he was falsely arrested, interrupts repeatedly, and pushes a judge too far. Finally, the judge cuts him off and grants his attorney's motion to withdraw. Just like that, Alan is left without representation, stranded mid-case because of his own stubbornness. It's the ultimate collapse, both dramatic and inevitable. If you enjoyed this breakdown, don't forget to like this video, hit that subscribe button, and we'll see you in the next one.
Possession of my daughters back in 2020 and asked me if they were at my house. And I told him, no, they were not in my possession.
Let me interrupt you. Your rights were terminated. From what I read, that went to the
Wrongfully.
Excuse me, don't interrupt me. That went to the 7th Court of Appeals, and it was affirmed on November 26th of 2018. A petition for review was denied by the Texas Supreme Court. On June 3rd of 2019, the mandate issued. So your rights are terminated. And if you don't understand what Ms. Stratt was saying, the statute that allows you to ask for reinstatement of your parental rights, you must prove to the court that the children have not been adopted and the children are not subject to an adoption placement agreement. Plus, you have to have given notice 45 days prior to filing your petition to the department. These exhibits that have just been admitted show that the children have been adopted, and they show that you did not give 45 days notice of the filing of the petition prior to filing it. You gave the notice on the same day that you filed the petition.
No, sir, I did not.
Well,
I gave that notice in December, and I have proof of that.
According to let me interrupt you. The children are adopted. Unless you can convince this court today that the children have not been adopted, I have no choice but to dismiss the case. That is a prerequisite to you to even file the petition.
They were adopted illegally.
Okay,
what do you want me to say about the illegal part of terminating my rights?
That is not what the statute says.
Does not the state of Texas say that they support fundamental law? If the state of Texas does not support fundamental law, then I wouldn't be arguing the fact that the adoption was done illegally. They never found a basis to terminate my parental rights. I'm
sorry, I'm going to interrupt you one more time. The statute says you cannot file that, or it'll be dismissed if the children have been adopted. It doesn't say that the children have been legally adopted or illegally adopted.
So you're saying an illegal action can be done in a court?
I'm saying what I just said. The statute says if the children have been adopted, then I have to dismiss your petition for reinstatement, and that's where I'm standing. So that's my intent today.
If you dismiss this, Judge Graham, Associate Judge Graham, I should be seeing a judge who has standing. You are an associate judge. You are just a lawyer. Do you understand that you right now are violating my constitutional rights as you did 8 years ago?
No, ma'am, I don't. So again, unless you can present evidence that the children have not been adopted, I'm going to dismiss the case right now without any further testimony because the exhibits that have been admitted show that the children have been adopted.
And the other exhibits stating that I did not file are not proving that I did file 45 days. That's not the state lying right there.
Petitioner's Exhibit 2 is a certified copy of your notice of intent to file this petition. It was filed on March 14th, 2025 at 8:51 a.m. Your actual petition for reinstatement was filed on March 14th, 2025 at 8:51 a.m. So yes.
That is incorrect.
Well, that's
on December 30th.
You can take that up with, you can take that up with the district clerk because they have certified that these are accurate records. Mr. Nowak, you want to weigh in on this? You represent the children. Do you have recommendations for the motion today?
I do, Judge, and I so appreciate your temperament and your patience. Mom's rights were terminated. The kids were adopted. I'm not going to disrupt that adoption because some crazy lady has some crazy theories.
Excuse me?
I apologize for that, Judge. My recommendation to the court today is to dismiss whatever mom has filed. And Judge, I do apologize for my commentary earlier.
That's fine. Okay.
It may be fine to you, but that's defamation of character, Judge.
Yeah, well, you know what? I'll defame your character all day.
Did you admit my,
I
my
haven't.
five
No.
exhibits?
Are there objections to 1 through 5?
And I named them departments, exhibit 1 through 5, since I guess Mrs. Lessner is actually the petitioner in this particular situation.
Okay.
Well, no objection, Judge.
Okay. All right. Petitions
Of course
1 through 5 are admitted. The court finds that based on department's exhibit number 1, that the children were adopted
Illegally.
and
Under the table. I never got the adoption
Thank you.
papers because they knew back in the day I would have argued that till the
Listener,
cows.
I'm getting ready to mute you if you interrupt me one more time.
Oh, but you can interrupt me, right?
The order granting adoption was signed. It's in cause number 78010-L1 in the county court at law number 1. That order was signed by Judge Anderson on June 10th, 2020. And I'm looking at a certified copy of it under Department's Exhibit 1. Court finds that Ms. Lessner has not met the basic requirements to go forward with this petition because the children have been adopted. Therefore, I'm going to grant the motion to dismiss. All right, Ms. Lessner, you have 3 days, working days from today to file a de novo if you'd like for Judge Anderson to rehear this case. You have 20 days after I sign the judgment when it's presented to me to appeal this to the Court of Appeals. You understand that?
I'll see you in federal court.
Okay, I'll see you then. All right.
Good.
That's
All of you.
This was our last hearing for the day, so we'll stand in recess. Everybody have a good weekend.
You too, Judge. Thank you.
You too. Thank you.
Good to
Judge,
see you.
it's always good to end my week with you. You have a wonderful weekend, my
Yeah,
friend.
well,
Thank you so
usually
much.
It's usually interesting on Fridays. I'll give you that.
This one
It's
was
nice to
different.
see how much you all know each other and are so